Please be seated. We are now to our second case on the oral argument calendar. That case is case number 23-371, TKH Coastal Property versus Talcor Group. Is counsel for the appellant ready to proceed?
Yes, Your Honor.
You may come forward.
I've stood here before and forgotten my name, so I'll try not to do that today. I am Howard Sutter. I'm here on behalf of TKH Coastal Property Investments appellant. The law of the case doctrine
And Mr. Sutter, thank you for that. Would you like to reserve any time for rebuttal?
I don't think I'm going to need anywhere near the 20 minutes. I'll take 10 on reserve, please.
Okay, that's fine. Please proceed.
The law of the case doctrine exists precisely to prevent me and you from being here today. I'm kind of an old guy. I've reached that point in my career when I can call myself an old fart. And when I first started practicing law, you take my remarks a little off on a different tangent, I promise you this point. I remember being frustrated by the concept of a PCA, or the slightly more rare PCR opinion, and I was upset about it. I finally became educated. Still, I often hear attorneys complain about it, and I try to set them straight and say, purpose of a PC opinion is basically for the parties, and it tells them what was decided, but there's no need, it also says there's no real need for an opinion. You don't have to give a long, wordy discussion about why we decided, and you can tell from the order which side was the prevailing side. Makes sense. Pretty much what we have here. When you file a motion, and you see the response, and the court rules, you can understand perfectly well what the court was saying, even if it doesn't give you a long opinion. In fact, that's common. It's very common to have also...
Yeah, but a PCA, it could be for jurisdictional grounds, it could be on the merits. So it doesn't say, then how do we know?
Well, we know by what was filed, and the parties in the PCA know what the arguments were presented on the other side. So the statement to, and this came, I became educated by this by reading a Bar Journal article back in the 80s. This is, the court is saying, we don't adopt your position, we adopt the other position if you were the loser, or we adopt your position if you were the winner. So you do know.
Well, I know from my experience, sometimes there'll be a motion before the appellate court on a substantive issue, but the court panel says, well, in looking at this case, hey, it's a non-appealable, non-final order, dismissed on jurisdictional grounds.
Well, there's a simple, I guess one of the things that you might say about a PCA is sometimes you don't really want to know all the reasons why the court ruled, because they might be embarrassing to you. So that's one reason why you might not necessarily know all of the reasons that are behind the PCA, but you are still left with, that was the decision of the court.
It seems to me in this case, what's the legitimate scope of the law of the case doctrine? So I think if we could focus on that, that'd be helpful.
All right, well, so in this case, what happened was the appellee filed their motion for a contingent award of appellate attorney fees. They attached to that motion their motion below. That gave the substance. That's part of 9-400. You must give the substance, what have you. So they gave the substance. Then the court denied it based on that. They filed another motion for reconsideration of that, and in that situation, they attached the actual proposal for settlement that had been below. So they fully documented what was going on, fully documented their argument, fully stated the substance of it. By the way, the motion for reconsideration is not in this trial record. It's in the first DCA's docket sheet, but it's not in this particular record on appeal.
So they denied the motion for reconsideration.
They did deny the motion.
So let me ask you, the next step is, then you're back in trial court. You argue the law of the case in the trial court, correct?
Yes.
And the judge goes ahead and orders entitlement, correct?
That's correct.
Okay. But then you file a motion to enforce the mandate. And it's well argued. You cite the Langer case. You go through great detail and then the first DCA denies that. So how are we to read, you've got two where you've been denied, and then it seems your position is denied. How are we to read that denial of the motion to enforce the mandate?
I think that the motion to enforce the mandate was premature, and that's why it was denied.
You think it's because they didn't have because only entitlement was ordered and he had not determined the amount of fees? Is that?
No, I'm not sure I'm following the order of the matter in this regard. It seems to me that, and by the way, I didn't argue any of this. I'm here on a limited appearance for this argument.
So
I wasn't present there.
So entitlement was granted below.
Entitlement was granted
When
below.
the entitlement was granted, then a motion to enforce the mandate was filed, argued, which I think was argued very well on the same type of arguments that you're making here in your brief. And then the first DCA denied that. And so the question is, how are we to view that denial when you're arguing basically the same thing that you're arguing here today?
It seems to me that that motion could have been denied for a number of reasons. That's true.
The same as the first two, correct?
Well, yes. I'm still not completely sure about the timing though, in terms of whether or not it would have affected the trial courts going forward. Just because the motion to enforce the mandate was denied doesn't seem to me to be a direct ruling on whether or not there should have been entitlement considered. It may just be a timing issue in terms of what the court said, well, this is not the right time for us to consider this at this time.
But I think Judge Boatwright's point would be mine as well. I mean, your whole argument is predicated upon a denial, and us elucidating that in a way to perhaps make it more than it was or not. But isn't that the same argument they make back against you as to the enforcement of the mandate?
Well, let's come back to the idea then that we're here de novo. So really we should be able to look past those things and say, we now have to determine whether or not it is correct to have an entitlement to fees. So we're de novo, and that's to our advantage, certainly in this messed up order of things.
So, and just make sure I understand that. So they cancel out the denial and the motion to enforce, and so we're here de novo. So we evaluate the propriety of the proposal based on the complaint, correct?
Based on the complaint, based upon also your prior order denying fees, which is of course what the law of the case is all about. Whether or not you're instructing the trial court how it can continue.
Well, I think that's my point. If it's truly de novo and they cancel out, I thought that's what you were saying. And then we look at it de novo. And so just so I understand the argument, your client's initial complaint pleaded, among other things, a request for an equitable lien.
That's correct.
And as I read that provision I've got here in front of me, it asks the court to impose an equitable lien. And so your position would be that was purely equitable, that the proposal of settlement said this is to dispose of all claims, and by virtue of that, based on the line of cases that say that this is a mechanism for a civil action for damages under 768-79, that this proposal would not be appropriate. Did I get that correct?
That is correct.
So what is your understanding, counsel, of what an equitable lien is? I mean, what is an equitable lien?
As opposed to a lien of law?
Yes, sir.
Well, I think it just depends on it. A lien at law would be something that derives either from statute or from contract or from some other thing. And an equitable lien is based upon an equitable claim against the parties or against the property that is sought to be liened. So it's just a question of, it's just a question of the underlying basis for the lien.
And here, your client's pleading asks for that lien to be visited on property, correct?
Yes. Specifically on monies, as I understand.
Well, it also uses the term, and again, I've got it in front of me. It says, wherefore the plaintiff prays that the court impose an equitable lien on any property owned by TGI.
Well, part of that would be, so for example, to distinguish between at law or at equity. At law, your lien would be against a specific piece of property under a contract or a statute or something of that nature. Here it would be, we don't know where the property is yet, and we'll have to wait until we find out.
It's still financially based though, correct?
Well, of course.
So then it would go to damages, which could be argued that the offer of judgment statute then applies, correct?
I suppose it could be, almost everything that we talk about really goes to damages at some level. So I'm having a little trouble with that distinction. Yes, is the answer though. It goes to a form of damages and enforcing a claim against a piece of property. Yes.
Well, isn't that their argument back then? That this brings it back within the realm of the proposal of settlement statute? I mean, as I understand, that's the essence of the claim, that this is tantamount to a claim for damages, as opposed to a pure equity claim, which might be an injunction.
Wasn't there also a claim in there for an accounting? And I think part of the other problem is when the DCA first.
Where's the accounting in the initial complaint?
Well, then that's an interesting question, because one of my questions is, why should it be that we pick just that first complaint?
Well,
Why-
because
why-
Copeland, and I was part of the panel, I believe, in Copeland, first DCA says that's the proposal you look at. You look at the complaint that was in effect at the time of the proposal. And now, are we bound by the first DCA? I don't know that we are, but that seems to me a pretty good statement of the law, because the evaluation point would be the pleading at the time you advance the proposal. Now, would you say
Well,
Copeland's wrong about that?
I'm not sure that there was anything in the statute then that would have triggered it. That complaint was not dismissed with prejudice. There was an amendment. So I'm not completely certain that looking at the specific offer of judgment statute that there was a trigger for that. I can understand the point, although.
Doesn't it make logical sense, though, if you're trying to evaluate the good faith of the proposal, wouldn't you look to the pleading that was in effect at the time the proposal was advanced?
Well, yes, of course.
So we're bound by, as far as our analysis, the initial complaint.
Yes.
Is accounting in the initial complaint?
I thought there was, but I'm not going to make that statement right now.
I can try to search it. I don't remember seeing that, but I can certainly look. But you don't, you believe it was?
Let's see. Well, I'll have to come back to that if I can. So here, they made their motion. It was denied. They made their motion for reconsideration. It was denied. They go back down to the trial court and they tell the trial court, we don't understand the basis of the ruling. I submit that that is not a valid argument to the trial court, given that they provided all of the basis of the ruling to the trial court, to the DCA. They gave their underlying motion. The first, at the time, certainly had an opportunity to look at that. They also had the opportunity to look at the response to that, including all of the arguments that we've just been talking about versus equitable and all the rest of that. Nobody distinguished at the time whether or not it was the first complaint, the first amended, or the second amended. Nobody made that distinction.
So it appears the fourth DCA, this is where this is the case law that you're relying on, two cases out of
Langer.
here. They seem to focus in on the key is the merits of the fee motion itself. So in this case, do you believe the motion and the motion for reconsideration were sufficient on the merits?
Yes.
Okay, and why is that?
Well, because just as in the rule, it says, you will give us the substance of your argument in favor of fees. That's what 9400 says. You will give us that substance. So they gave that substance. In the Candy World case, which is the case that the other side relies on, which, by the way, is the same 4DCA, but 16 years earlier, so they certainly saw that. They knew about that case when they ruled in Langer. In the Candy World case, it said that the motion in the appeal offered no explanation about why they would be entitled to fees.
That's what I was asking, is the substance of what was filed here by the appellee at the appellate court, you think was sufficient on the merits for the first DCA to make their decision?
Yes. That's it exactly. And then along comes Langer v. Fells, and they say, they add a little something to the thing. They say, now, the law of the case doctrine, and this is almost immediately following the Supreme Court in Diamond. The Supreme Court in Diamond ruled in January, Langer was in February of 2013, and they say now it includes not only issues explicitly ruled on by the court, but also those issues which were implicitly or necessarily considered by the appellate court's decision. And we submit that that is the case in this situation. So even if it's not explicit, and I think because they provided all of the substance in their motions, all of it, including the proposal for settlement, that was explicitly considered. But even if it were not, it would be implicitly considered. And then they come back here in this court, and in their brief, they say that the proposal for settlement was not in the record. Well, they had put it in the record. So that's incorrect. It was, in fact, in the record when the first panel ruled. And I want to make sure that, I don't think there's a distinction really, 1 DCA, 5 DCA. The only thing that I think would make a real difference here is if there was some conflict in existing 5th DCA case law. Then it would be of some concern because you'd have to be picking 1, 5, that sort of thing. I don't think that's really an issue here.
Well, you have 4 minutes and 20 seconds left for rebuttal. You're welcome to reserve that, or you may proceed.
I'll reserve. Thank you.
Good morning. May it please the court. My name is Lee Wedekin. I represent Applee Talcor here today. I've represented Talcor since the beginning of this case. First, before I start, I'd just like to thank and commend the 5th District for allowing us to appear here in Lake County today. I know as a Jacksonvillian, speaking to a few Jacksonvillians, it's very convenient. This is the shortest drive I've ever had to an oral argument, so it's great to be here with you this morning. There are 2 reasons why this court should affirm the circuit court's orders on entitlement and amount of fees and to enforce Talcor's proposal for settlement. The first is that this is a civil action for damages. I know that there's some dispute or discussion in the briefing about equitable versus non-equitable claims. I think that's an incorrect distinction. I think what you really need to focus on is the language of the statute, which says in a civil action for damages. And so really the statute is focused on what remedies are being sought. And I think that the court has correctly identified that in the operative complaint, which is the initial complaint, that every single cause of action, there were 5, including the claim for an equitable lien. Each of those claims seek damages.
What do you do, Mr. Wedekin? And again, I've got the operative complaint of the initial complaint. 5th cause of action, equitable lien. Paragraph 31 reads, an equitable lien is not an estate or property in the land itself, nor a possessory right of any kind. It is a charge or encumbrance upon the land, so that the very thing itself may be proceeded against in an equitable action. How is that not the essence of equity? Help me understand.
Sure. The distinction really isn't between legal claims and equitable claims. It's between claims that seek damages and claims that seek non-monetary relief.
Agreed.
Okay.
I've read a lot of cases last night, and they do say that.
So what I would focus on isn't paragraph 31, but the following paragraph. So paragraph 32 and 33. Paragraph 32 explains exactly why the plaintiff is seeking an equitable lien. It says in the 4th line of paragraph 32, for the purpose of restitution of the money wrongfully retained by TGI, which is Talcor the defendant. That's the purpose of the lien, is to attach to the money. It's all about damages. And so you'll see the paragraph 33 that goes on to talk about, that's the kind of the wherefore clause, although it's enumerated. It says it asks that the court impose an equitable lien, which can be traced to the money that Talcor received. Plaintiff further prays for other damages associated with this action. And then finally, for all consequential damages and general damages and such other damages as the court may deem proper. And so it's clear from the equitable lien claim that it is really a claim that relates to damages. This is the entire purpose of the complaint is to seek damages. That is I think the Javelina case talks about what the real issue in the case is. And the real issue in this case, as pled in the initial complaint, is damages. It actually says it's a complaint for damages.
Well, in your proposal, your client's proposal in this case said it was in settlement of all claims. I know there is a differentiation in some of the federal cases, 11th Circuit case, a couple of Middle District cases, that where there's that omnibus language in the proposal. There may be a question about whether that subsumes equity claims as well. I mean, how do you get around that based on the broad nature of the language of the proposal here?
Understood. So the way that we examined the complaint and the reason why we crafted the proposal the way that we did was because we perceived all of the issues in the case to be related to damages. And so we didn't feel like it would be appropriate to carve out the equitable lien claim and leave it remaining, because there would be no purpose to that if the whole goal of the equitable lien claim was to attach to money that had been transferred. The essence of the complaint is allegations that my client fraudulently transferred funds away from the plaintiff entity, TKH. And the purpose of the equitable lien claim was to follow the funds and attach to whatever funds if they had been converted to another form of property. And so we felt like that was all part and parcel of the same damages claims, and so that's why the proposal was crafted in such a way as to include all of those claims.
So in regards to the argument that this should be barred by law of the case, they have relied on 2 4th DCA cases, correct?
Yes.
Okay, and seems to me what those cases seem to say is that if the appellate court was able to rule on the merits of the case and denied, then that would be the law of the case. So you filed an initial motion for appellate fees, correct?
Correct.
It seemed to be pretty detailed. Then that got denied, and then you came back and filed a more detailed motion, correct? And then attached the offer of judgment.
The concern that we had when we...
Well, I guess the question before you do that is, are you saying that the 2 motions that you filed would have been insufficient, or you were the trial counsel, correct?
Correct.
So were those 2 motions insufficient for the court to rule on the merits?
Yes, absolutely. And here's why. And that's not even what we wanted the court to do. What we really wanted the First District to do was not to rule on the merits of whether or not we were entitled to fees based on the proposal.
You asked conditionally.
Correct.
Conditionally.
That's
But
right.
They denied that also.
That's correct. And the reasoning behind that is lost, is a mystery. And anybody who tells you otherwise, respectfully may be trying to say
So
something.
you were asking conditionally, you were asking them to provisionally award and have the trial court make a decision, but they didn't even grant the provisional part of that, correct?
That is correct. And so our request was...
How was that not the law of the case then at that point?
Here's why. Because at the time that the initial motion was made in the appellate court, the First District, the evidentiary record was completely insufficient. And that is why Langer versus Phelps doesn't apply. It's completely distinguishable. In that case, which is the 4th DCA case that appellant relies on.
Candy World states, I'm just reading from Candy World states that they looked at the motion itself. What was the motion sufficient?
The motion itself was not sufficient and didn't even ask.
Are you saying Candy World or yours was not?
Sorry, mine.
You filed.
Correct. And it didn't ask the district court to rule on entitlement because we knew at the time the district court couldn't rule on entitlement because of the nature of the evidentiary record currently in place at that time. So,
are you saying that an appellate court cannot make a decision on appellate fees for an offer of judgment?
No. Conditionally, it could, but that's the point really that I'm maybe failing to make is that the motion only asked the First District to include appellate fees if, number one, we prevailed on the appeal, which we did, and number two, on remand, the trial court determined in its jurisdiction that the proposal was enforceable. because all that the first appeal predated the entitlement and amount issues. So really, the first appeal was entirely focused on whether or not the dismissal with prejudice of the Second Amendment complaint was proper.
So are you saying, I want to make sure I understand the reasoning, Mr. Whitaker, that the first rulings in that regard were advisory? I mean, you in essence were asking for an advisory opinion from them, and so we can disregard those?
Not an advisory opinion, but essentially that district court, if the trial court, and that's why it was deemed or determined or characterized as a contingent award, if the trial court determines that ultimately we are entitled to fees, that those fees would also include an award of our appellate fees.
Is there not an argument, and I just throw it out for whatever it's worth, that it was premature for you to ask for those things at that point, given what you're describing as no determination by the court as to entitlement yet?
It's possible, and unfortunately, we don't know why the first district denied the motion. I wish that we did; it would have been very helpful. But as the
Well, my experience at the first district was that we then had a extensive list of orders for attorney's fees, because there's all kinds of issues that come up. And one of them was that it was used in these situations, perhaps, where there's a request for appellate attorney's fees. It hasn't really been determined below yet whether this offer of judgment or whatever statute applies. So we do a conditional, it's an order, it's a conditional order saying we condition order, as you said, based upon the determination by the trial court that they're entitled. So they didn't issue that order in this case, though.
That's correct.
If they had, we wouldn't be here.
That's correct.
Right? So
Presumably.
the question is, did they, by having nothing in their order other than a denial, basically rule on the merits? And if they did rule on the merits, I assume you're not entitled to appellate attorney's fees in this case.
Okay, so taking those two,
Right.
yes, they did not and could not have ruled on the merits of the motion.
Because you didn't ask them to.
Correct, and it couldn't have done it even if we had asked them, because at that time, there was no evidence, there was no record for the first to have looked at, to have said, yes, you're entitled to. So there was
Well, then that sounds to me like you didn't provide an adequate motion, so they denied it because it was inadequate. So therefore, it's all the case.
well, it's not law of the case, and we could never know, unfortunately, why the denial. And that's part of the problem with
What would have needed to be in the record?
I would go to Langer and say that was a completely developed record, which is why the law of the case applied there and not here. In that case, entitlement and amount had been determined through multiple motions that were filed. They were argued, hearings, they had transcripts, the proposals had been filed in that case. And so the district court could look at a completely developed evidentiary record. Here there was nothing. We had filed a 1 or 2 page motion in the trial court to grant us fees, and it cited the statute and rule, and that was about it. So there was just not enough of a record for the court to have ruled on the merits of the entitlement based on the proposal.
But there's enough in your view for them to have issued an order provisionally granting fees.
I had hoped so. I don't know why they didn't, though. And that's part of the problem with this, the legal ventriloquism of attempting to divine the meaning behind a summary denial of a motion. And that's the entire issue here, is that we don't know. We don't know whether it was a merits determination, it was a procedural error, or anything else. And so in the absence of knowing, you can't just conclude, as TKH attempts to do, that it was a merits-based decision.
At the time of the appellate court's order, there was pending in the trial court a motion for fees, correct?
That is correct.
But that had been stayed or held in abeyance until the appeal was over. So, I mean, was there any action on that motion while the case was at first?
No.
So just by the agreement of the parties, it just sat there?
My recollection is that there was a dismissal with prejudice on day 1. On day 2, we filed a 1 or 2 page, very brief motion for fees based on a statute and rule. Within a week or so after that, there was an opposition filed, and then nothing else was done pending the notice of appeal that was filed. It goes up to the first. We have a PCA, and then this order. We move for reconsideration, also denied, and so then we go back, a mandate's issued, we go back to the trial court. At that point, we argue entitlement, and as Judge Boatwright pointed out earlier, there was a motion to enforce the mandate filed with the First District, who again summarily denied it. And so we're left with a mystery as to what the First intended with its denials of these motions. So in the absence of knowing one way or the other, the law of the case doctrine does not apply. And so that's really, to me, logically, the first step that the panel would take is to determine whether or not the law of the case applies or not. If it doesn't, or if it does, then the result is obvious.
Do you agree Langer is good law?
I don't think it's-
That was a summary denial in that case for free fees, which I don't understand what you're arguing, but they did say that was the law of the case. So do you agree that case in Candy World is good law?
It hasn't been overturned yet. It has been, I think there's one case that refused to follow the fourth DCA case. I'm sorry, I lost it, Langer. Candy World is older, but they both remain technically good law. I don't think that it should be followed. I don't think that they apply in this case to these particular.
I know the trial court raised the issue, was this even possible? It was kind of the first thing that you discussed. Did you ever present Langer to Candy World? Were any of these cases presented to me below at the initial fee hearing?
The fee hearing,
When you were going forward on entitlement? I know it was one of the first things that he asked.
he mentioned it. I remember Judge Roberson talking about it, and he, I think, very quickly determined that the mandate did not prohibit him from determining entitlement because of the absence of
but
guidance.
Did you ever tell him about the Langer case or the Candy World case?
Well, the Langer case is not my case. I cannot remember if the other side raised it or not. I know that it was the predominant case that TKH relied on when it filed its motion to enforce the mandate with the First District. I don't remember whether or not they raised it at the entitlement hearing. What I do recall is that the language that they used was that TKH anticipated, I remember the word, they anticipated the basis for the First District's denial of the motion for fees was for a variety of things that it couldn't possibly be based on, including an analysis of the proposal that wasn't in the record at the time that the motion was denied.
Would you spend a few minutes on the manifest injustice? Because, argument you raised, because as we sit here today, if we had to decide, hey, the First District messed up, they should have provisionally granted that order should have gone out. Here the trial court has gone through the analysis, has determined that the offer is enforceable and awarded fees and all that. So I assume your argument is, Your Honors, it's a manifest injustice because here we have an unusual situation, that's what's required, in the rare case for appellate court to revisit the ruling to ensure that justice prevails. That's your argument, right?
That's correct.
So if you could just expound upon that.
Thank you. So the manifest injustice is an exception to the application of the law of the case doctrine, which says that the law of the case doctrine, even if it does apply, it shouldn't be enforced in the event that it results in a manifest injustice. And Judge Makar, just as you just pointed out, the manifest injustice here would be we have gone down to the trial court, which is the proper venue for determining whether or not a proposal is enforceable or not. Judge Roberson did that. We had motions. There was substantial motion practice, argument. He determined that they were enforceable. And so now it would be a manifest injustice given that he has determined entitlement and amount for this court to say, well, hold on, there was an appellate fee motion in a prior appeal that was denied without explanation, and we're going to rely on that instead of the trial court's analysis based on an evidentiary record and argument of the parties and through a hearing and all of that. So that would be our argument to say essentially the law of the case does not apply. However, even if it does, the court should ignore it or at least refuse to apply it in this case to these particular facts because of the unusual circumstances.
And we have to first conclude that the trial court was correct in his analysis and awarded fees.
That's correct. So yes, that's kind of the second piece of this. So if the first analysis is to decide whether or not the law of the case applies, and if it does, whether or not the application here would result in manifest injustice. The second component would be an analysis of whether or not Judge Roberson improperly determined that the proposal was enforceable for whatever reason. And so the second piece of this really focuses on the statutory criteria and whether or not the proposal meets it. Our position is that it does. So number one, first you have to determine that yes, based on the claims alleged in the initial complaint, that this is a civil action for damages. Therefore, the statute does apply. Once you reach that, you would then have to walk through the statutory provisions to confirm that the proposal, which is now in the record, does meet each one of those criteria. And we walk through that in the answer brief and lay out exactly why the proposal was procedurally proper and that it was done within the correct time period. It met each one of the various substantive criteria. And also, I know it's been raised that the amount wasn't made in good faith. That is a separate issue. It was a $500 proposal that was made the day after our motion to dismiss was filed, a motion to dismiss the initial complaint based on the doctrine of res judicata. Ultimately, that is, after 2 subsequent complaints, that is the reasoning that the trial judge at the time adopted in dismissing the complaint with prejudice. So ultimately, that argument was vindicated. We were correct. And so the $500 represented a reasonable estimate at the time that the proposal was made. Thank you.
Thank you.
Give me 6 seconds of his time. To address your question, in the motion for reconsideration, the language is in particular of their fees in the first time. In particular, appellees should have been awarded entitlement to appellate fees, even conditionally, and they emphasize that, because it is prevailing party on appeal. So they did raise it not just contingent. In answer to another question, our motion for reconsideration below, when the trial court first granted entitlement,
Well, there's no question they were prevailing on appeal. They got a PCA.
that's correct. But I mean, my point is, they had asked right then for the fees at that time, not just contingent on a finding of entitlement.
Okay, I'll have to look at it, because you're saying they actually wanted the appellate court to determine the amount of the appellate fees.
Yes. That's what it says in their motion for reconsideration. Yes, the first one does say contingent, and you address the question of what type of order the court might have entered. The second one makes it clear that they were asking for them there. So at our 2009 and 10 is where our motion for reconsideration provides the court the Langer case. So it did come from our side. And we have the judge at R 2286. Well, I'm quite comfortable finding an entitlement to fees, at least at the trial court level. So it's noticing a distinction. Were you trying to get those as well at the appellate level, Mr. Wetkin? Mr. Wetkin, no, Your Honor. We're only seeking, and I think properly, this court is only authorized based on the first DCA's denial of our motion for appellate fees. We're only talking about trial court fees. Well, right there, the trial court was presented with a sort of an inconsistency. Because ordinarily, if you're entitled to them here, you're entitled to them there. If you're not, you're not. It doesn't go generally one way and then the other way and the other end. So it's the same basis, and that's kind of the key of the law of the case. One of the parts of the law of the case is that as long as the facts remain the same, the basis in the argument remains the same, then the result should be the same consistently throughout. So here, throughout, it has always been 768.79 and 1.442. So you have an interesting and a problematic situation here. The trial court has now divided the situation and said, okay, I'm only going to do it for the trial court. I'm not going to do it for appellate. They've been denied. Okay, that seems a little inconsistent. Right now, we're back.
It sounds to me they were waiving their entitlement to the appellate fees.
Well, are they waiving them now?
I don't know, but I'm not focusing on it.
Right.
What I'm focusing on is this case, which is, it sounds like that Mr. Wetkin may have said, well, we're not going to pursue appellate, we're just going to pursue trial. And then that doesn't necessarily mean he agrees with your argument.
It doesn't necessarily agree with the argument, but it's still inconsistent with the normal way that fees are awarded. So,
No, he's just, as I read that statement, I'm looking at it closely, he's basically saying, look, we try to get appellate fees from the appellate court, and they won't give us appellate fees, but we're certainly going to get our trial fees, because they haven't said anything about that.
well, when the law of the case is directed, of course, to the parties, but it's also directed to the trial court. So the trial court is being really specifically directed to the lower courts, telling you, don't do things that we have told you we don't want to do. So now the trial court is basically taking a position that, okay, I'm not going to award appellate fees, and yes, typically they come back and you ask for the fees in the lower court. That's typically what happens. But now the trial court is saying, well, I'm going to do it for just this, but not for that. That's inconsistent with the idea that the trial court understood what the mandate was. If the court allows fees now, that's against its initial ruling. If the court denies fees now, that's consistent with its original ruling. That's the law of the case. Thank you.
Thank you, Mr. Sutter. Thank you both. As they're clearing out, we will call the next